I am joined today by my dear friend Cody Blades, an attorney focusing on helping businesses and individuals navigate complex business and employment disputes. Her areas of expertise include employment, shareholder, and contract disputes. She's represented both businesses and individuals in wrongful termination, retaliation, discrimination, non-competition, and non-solicitation cases. In addition to all this, Cody also provides fractional general counsel and other advisory services to clients. Given your breadth of knowledge and the fact that you're awesome and all of your experience in the law, I am so grateful, Cody, that you're joining me today on Cupalo Conversations.
Thanks so much for having me. I'm excited to chat with you. Mostly just because I really like you.
Good.
Right answer.
Well, we've got a lot, I think, to cover. And I feel this is no small task. So today, I would love to dethrone the deep-seated belief that attorneys are only for the uber wealthy. Some of my favorite 90s and early 2000s movies feature the quote, "I need to call my attorney." But as we know, a lot of people don't call their attorney because A, they don't have one, B, they don't know where to find one, and C, they don't want to pay for one because it's also very nebulous, some of the payment terms. So I would love to dive in and let's start right out of the gate with, how do you find the right attorney?
Yeah, well, let me just preface this whole thing by saying I don't mind uber wealthy clients. If they want to hire me, if they're in the market, I'm available.
Perfect. No discrimination.
I don't discriminate against the uber wealthy, Lauren.
Good.
But no, they're not only for the uber wealthy. And I think it is sort of a misunderstanding because often what'll happen, well, a couple of things. First of all, if you're somebody going through a termination, like an employment termination, and you feel like it was wrongful, maybe you just told your employer that you were 3 months pregnant and need FMLA leave, at the end of your term, and they terminate you a week later and you think it was probably related, something like that. A lot of times you can find attorneys that will take your case on contingency. What that means is all of the risk is borne by the attorney and not by you. And that means that you don't have to pay your attorney anything. Sometimes attorneys will require you to pay costs, but usually in a contingency fee arrangement, you won't be required to pay anything. And then your attorney, only gets paid if you get paid. And usually that's like a 30 to 40% contingency. So whatever the take home is, the attorney gets 30 to 40% of that. I still represent employees, sometimes on contingency. It just really depends on the case. But I do a lot more business representation too. The reason we can't offer usually contingency fees for business disputes is because in the employment context, the employee, if they win, can recover their attorney fees. So there's sort of this stick you can use in negotiations of attorney fees to help aid in the contingency fee in the settlement negotiations. That doesn't exist on the business side usually. But even in some of these smaller situations where you're an independent contractor or you're an employee who's looking for another job, perhaps you have a non-solicitation clause, or perhaps you have a non-compete clause and you want somebody to look over this contract you've been handed. A lot of times in those situations, attorneys are going to require an upfront payment. So something called a retainer fee. Sometimes that retainer fee is going to be quite large, like maybe $5,000. Usually though, the attorney won't require that entire amount just to review a contract and have a conversation with you, but they want to make sure they're protected in case you need more advice. And so you'll have to pay that upfront cost, but then anything they don't use with their billable hour, they'll return back to you. So we have contingency fee, and then we have sort of this retainer arrangement. And then there's also, for mid-sized businesses, I've noticed a gap in the market for these mid-sized businesses who need regular legal advice. So they have all these employment questions, but they don't have an in-house employment attorney. In those cases, you can hire what's called a fractional general counsel, or I've been referring to it too as a fractional assistant general counsel. And that can be really helpful for these smaller companies who just aren't quite at the level of being able to afford, because a general counsel's salary, you're looking at $100,000 to $250,000 for a yearly salary for a general counsel. So those are different ways that you can, and I don't think I answered your question because I think your question was, how do you know if the attorney is right for you? And I sort of went into these different models, and I can answer that question too.
having started Cupalo only 7 months ago, I've now worked with 3 different attorneys who all have different models, all different pricing features. And it was really amazing to me to recognize that there are these. And so I would love to, yeah, let's go back to how do you find the right attorney? Because I do think that is a big part of it, is outside of which I appreciate, again, the clarity of the different types of models. So now knowing that, how do you find the right person for you and your needs?
But to me, I think the most important thing when it comes to hiring an attorney is, do you trust the person you're talking to? Are you getting good vibes from the person you're talking to? Do you feel like the person you're talking to wants to be a partner in your business or in your life if you're an individual, and not, are they sort of providing you a service and kind of don't want anything to do with you outside of that service? I think there are exceptions to that rule. If you have hyper specific industry, which requires hyper specific legal advice, and it's possible that the attorney you're working with may not be the most personable attorney, but may be the best attorney in that field, in your very specific field of whatever widget you're producing. They know everything about that widget and the history of it. Maybe you really want to be able to trust the person you're working with. I'm your partner to accomplish that goal. And that's the way I want my clients to feel. And if they don't feel that way, then I'm not the right attorney for them. And it's not going to work, because as soon as you start to feel friction with your attorney, that's going to cause you to not trust them. And then when you see the, point one opened email, right? Or, read client email, when you start to see that, you're going to start questioning, well, why are you charging me for looking at my email? Why are you like 6 minutes? Like, do we really have to charge this in 6-minute increments? Then there's just like a lack of trust, and everything sort of falls out from under there. You start hiding things from your attorney, which is never good for representation. So for me, it's about building that trust and about building that relationship to make sure that you feel like I'm a partner in whatever goal you're trying to accomplish.
Yeah, I think that's a great way to look at it, because I found, again, I can only speak from my experience, but I found that it was really intimidating coming to the table with my first experience, my first attorney building this business. I felt like I was coming at it from the lens of incompetence. Like I just felt like I didn't know what I didn't know. And so I didn't even know about, hey, I didn't think to ask, what are your what is your pricing model? I didn't negotiate. And that's a question I wanted to know, because you did touch on these different types of models. Can you negotiate? Is that something that people have the power to do?
Yeah, I want to empower everybody listening to negotiate with your attorney, because, you're in charge of the representation. You, as the client, are ultimately in charge of it. I have the expertise, and you're hiring me for my expertise, and we have to have a good working relationship. So obviously we don't want to be at loggerheads, but I negotiate for a living. Most attorneys do. That's what we do. We're really, really good negotiators. So we should be open to the idea of a client questioning us or negotiating with us about our fees. And then second, something else that negotiating or trying to negotiate with your attorney can do at the beginning is to sort of test how they respond, right? If an attorney gets really sort of defensive when you start to try to negotiate with them, it may be a good sign that they're not going to be a great partner for you in the long run. Because if you see, for example, sometimes double entries happen, right? Sometimes double billing happens where you record a call you had with the client, and then when you're going back and doing your time, you record it again because you kind of forgot that you actually kept time contemporaneously that day or whatever. And, if you're a client looking at that bill and you say, oh, I think you double charged me here, you as the client want to feel empowered to be able to do that. And if your attorney at the front end of the relationship can't handle you sort of pushing back on maybe the retainer fee or the arrangement that you guys are setting up, where does that leave you when something goes wrong on a bill? You know what I mean? It leaves you in a place where you feel disempowered from the very beginning. And you should feel empowered as the client to have an open, honest, communicative relationship with your attorney. It's better for you, it's better for your business, and it's better for the attorney, quite frankly, as well. Now, there have been times where I've had to set boundaries with new clients where they've been trying to take advantage of my expertise or my time. And I got to set those boundaries, but I know what my boundaries are. So merely having the conversation with me is never threatening to me because I know what I will and will not tolerate. And sometimes I'm just not the attorney for the person, right? If they're looking for a contingency fee arrangement, and it's a contract dispute case, and there's an attorney fee provision, but it's like, it's not a slam dunk case or something, and I can't do it, I'm not the attorney for that person, and they can ask somebody else, right? So it's not to say that the negotiations will always work or always go your way, but it'll give you a lot of insight into, how is this attorney going to work with you, right? You want them to work with you.
What I found with all three attorneys, I would say with the exception of one and the one that I'm working with now, who's here in New Hampshire, the first two I had failed to explain, and maybe it was just assumptions made that I would understand how a retainer works. The first time I was asked to put a $5,000 retainer down, and I went, holy shit, I have one question. How much is this question going to cost me, right? And it ended up costing me $200. And I thought that's reasonable. That's what I thought. And then the rest of the money, the $4,800, had been returned. But that was not how I understood it. So I was shocked and I just played the game. I went along. I acted like I knew what I was doing, very embarrassed. And then the second time there was no retainer and there was no explicit discussion of fees. I just kept getting these wild bills every month. And it was very nebulous. I had no idea what an email opening would cost, a phone call. So that's from the lens of, me as a business establishment. What are your rights as an employee when it comes to an employment contract? Because I've signed 5 employment contracts, never once negotiating them. What are some mistakes that employees make when marching into an employment arrangement?
When it comes to things like independent contractors, or when it comes to things like, an employee in a situation where they're, coming into a CTO position, or coming into a developer position, or coming into more of a position where they have a little bit more power in the negotiations, has a skill that the company really needs, and, they're the commodity that the employer wants to hire. I think that, people read the agreement and think that they don't have any power, when in fact, they do have power to read through it and to negotiate on this piece or that piece. I mean, you can do things is like, let's say you write an email back that says, I noticed this provision has a non-solicitation of 4 years. I'm fine with a non-solicitation, but I'd like it to be for a year after any separation of employment rather than 4 years. What happens in that situation is one of two things, right? Either they say, okay, well then you're not a good fit. Okay. So that's a potential. So you have to be okay with that outcome if you're going to negotiate that. Or they say, okay, well, let me take it to legal and get back to you. Right. So then the employer takes it back to their attorney and says, is this going to be okay? What are our risks here? How much do we want this person? Is it worth the headache? Whatever. And then they come back to you in any negotiation, whether it be for a settlement on a lawsuit, or whether it be for an employee. You are more powerful the more you're willing to lose, right? The more you're willing to not get your way on the contract and to walk away. So if you're in a position where you can't walk away, then you may not be able to negotiate those situations with quite as much force. But in a situation where you're okay to sort of negotiate and walk away, you absolutely can.
And that's what I think. A lot of times, to your point, we don't feel empowered. We sign things, we accept things, we just go forward because, to your point, maybe we're not in a position either to risk turning down that opportunity. But I also think there's another more sinister one, which is people are afraid to look stupid. I'll admit, I think people are afraid to call up an attorney and say, I would like your help walking through this. And that's where I've learned so much in the last few months of you have to be willing to make that call and get help, because this isn't stuff that you were supposed to understand. In a lot of ways, the language is confusing, and with a little bit of shepherding through it, you walk away feeling empowered. So I think that's a good reminder, be it for employees or independent contractors, that you don't have to understand all this, but I do think it's good to get help. On the other side, so that's at the start of an employment type arrangement, or a consulting type arrangement. What about for people who willingly walk away from an opportunity? They leave their employment. Do they have power? Do they have any rights to negotiate after the fact? Like, I know I accepted that 4-year non-solicitation term in my contract, but now that I'm actually now that the moment has come and I realize this would prohibit me from doing business, do people have power after the fact? And again, this is one of those things I never learned, so I don't know if we do.
But yeah, I mean, absolutely. So I have a I have another client who regularly is contracting. So they're in like a 3-month contract, and then they're in a year contract, and they're constantly walking into contracts and walking out of contracts. And they have had ideas during the course of their employment that they've wanted to monetize. And sometimes those ideas will belong to the employer when you're under contract. And so, I've drafted emails for this client for them to send to their employer to just say, hey, will you let me out of this provision? And sometimes just employers don't really care, right? They put that in there for specific people, and it ends up going to everybody, but you're actually not their target. This other guy is their target. And so the worst thing that can happen if you ask in that situation is they say no. And then you've got to figure something else out. But maybe you ask and they say, okay. You know what I mean? And I've had that happen where they'll just come back and be like, this isn't that important. To me, it signals this isn't that important to us. So yeah, we can let you out of that provision. So you absolutely have power to negotiate afterward. And again, where I come into that is let me give you the education that, let me give you my knowledge so that you can walk into it knowing where the pressure points are, where I think they're likely to cave and where I think they're not likely to cave based on my experience. And with your goal in mind, let's form a strategy. Let's form a strategy from point A to point B, and then you can execute on that strategy. Because like you said, so much of it is just about like not knowing what you don't know. And that's what I'm here for. I know some of the stuff that you don't know. And so like hire me, pay me for the knowledge that I have, and we can figure out how to get you to where you need to be, right?
I would love for people, again, listening and to walk away from this thinking like there can be a lot of help. I don't even cut my own hair. I pay someone to cut my hair. It's pretty like lowball stuff here, but I think we get into this mindset of we should be able to do this. We should know, and that's what I wanted to talk further about is, as people set up businesses, because having just gone through this, I have seen so much out there, such misinformation about just spinning up an LLC, just start your side hustle like that. And I feel there's a terrible disservice to that. Not that I don't think people should be empowered to take something they're passionate about and turn it into an income source, not at all. Or to leave their W-2 and start their own business. But I do not think people recognize how much goes into that and how important it is to have a shepherd through that process, because it's not only from a legal perspective, but tax perspective. And so, right. But speaking specifically about legal, can you walk me through somebody wants to set up a business or a side hustle, again, either a full-time business or a side hustle? Where do you begin with them if they have, again, that earnest desire to, go after their entrepreneurial pursuit, but they've never worked with an attorney before? How would you walk them through that process?
Now, if it was a brand new business and they said, okay, should I choose an LLC or a corporation for tax, for what's the best for tax purposes? I have 3 other investors that I want to bring in, all that stuff. It kind of depends, but I would probably refer them to an attorney who does more of the setting up the business aspect of it. But I think it's an excellent idea to get an attorney on board in the beginning. And there's a couple reasons why. One, because I think a lot of people don't understand that the reason you're setting up an LLC, the reason you're setting up a corporation, depending on what it is to protect you from personal liability. So if you have an LLC or you have a corporation and somebody gets angry at your business, they sue your LLC or they sue your corporation. And because of this thing, this LLC or this corporation, your assets are protected. So you're not going to lose your home and all your life savings because of somebody who got angry at you and your business. Now, what people don't understand is that you have to do certain things in order to protect your business, in order to protect yourself, even if you set up an LLC or corporation. One of the biggest mistakes we see on the back end is what's called co-mingling of funds. So this is where you've set up that LLC, you've opened a bank account for that LLC, but in reality, like you're just sort of tossing money from your personal account to your business account and you're just sort of paying for your haircut with your business credit card, and you're, paying your tax bill with your personal checks, and you kind of just don't care, right? Like you don't care which bank account it comes out of as long as it's paid. The problem with this is courts will look at these, there's like 8 factors in Minnesota or something like that. They'll look at these factors and say, okay, you've said you're an LLC company, you've said you're a corporation, but are you really, or are you just the piggy bank for this person sitting behind you? And if that's the case, the courts can reach what we call reach past the entity and reach into your personal funds. So that's where it's really important for new business owners to get some legal advice on the front end to say, okay, how do I build this thing? And how do I set it up in a way structurally so that it remains an entity unto itself and I am not held personally responsible? So in addition to avoiding commingling of funds, another thing that an attorney can do from the very front end is to set up things like operating agreements, articles of incorporation, bylaws, stuff like that. Now, you may be saying to me, Cody, I'm the sole owner of my business. There's only one of me. I'm the owner, the operator. There is nobody else. Like, why in the world do I need an operating agreement? But again, it's because of these, what we call corporate formalities. So again, it's because the LLC and the Inc. exist, but they only exist insofar as they're following corporate formalities. And part of those corporate formalities are having documentation that you would have if you had 10 shareholders as part of your Inc. or 10 members as part of your LLC. And if you had that many people, you should have something like an operating agreement. And so even if it's just you're the sole owner, sole operator, you want to have those documents in place just to ensure that you're following the rules, even if it seems sort of silly, even if it seems like you're playing, like you're having a tea party with a stuffed animal, right? Like it's going to seem a little silly, and that's okay. But it's important to have those things in place. Another reason why this comes into play is like I had a client who had an operating agreement, even though she was the sole owner and operator, but then she wanted to bring in another member to her LLC, and she wanted to give that member 10% of the company. Because she already had an existing operating agreement, first of all, it was less expensive for us to do the work to modify that operating agreement to fit her needs, because there was already an existing document in place and we didn't have to sort of like pull one out from the templates and, structure it to fit her business. We already could kind of see how she wanted her business to flow in an ideal situation because she had set it up. And 2, it allowed us to get real clear about the goals of this 10% person coming in and how that might affect the rules that already exist and what rules needed to be changed in order to account for this other 10% owner. So that's another reason why it can be good to set it up, even if you're the sole owner shareholder. If you are not the sole owner shareholder, even if the person you are starting this business with is your best friend from childhood, it's your brother. I mean, it's your brother, right? That's who you're starting this business with. Blood is going to, get you through anything. That is so false, Lauren. Our biggest, most expensive, ugliest fights are on the back end of a shareholder dispute between family members when there's no operating agreement. That is an ugly, expensive ass fight.
Yeah.
So it's really important, even if you think, oh, this will never go wrong. You must that's when you need an attorney, because they'll tell you it'll go wrong because they've seen it go wrong 1,000 times. And, to have things like what happens if there's a tie? What happens if one person wants to spend the profit, distribute the profits to the shareholders, and the other person wants to put the profits back into the company to buy new equipment or whatever? If there's a tie in how to handle that, and there's no rules for how that tie is broken, you're in a situation, man. You're in a pickle. So think about, and you don't have to think about it. Hire an attorney to think about what happens in those situations and how to deal with those situations in an agreement so that things can run smoothly once you have the business up and operating. There's a lot of different reasons why operating agreements are good. And the only way you'll know how it'll work in your company and how it'll be good for your company is if you talk to an attorney who's seen it go wrong and who's seen it all before. And they can tell you, well, you could do it that way, but here's what here's what's going to happen if you do it that way. You know what I mean? And that's like, if you have more than one owner, like get an attorney.
Having an attorney who's been there, done that, and has seen things go awry is really important. And not that it needs to be all, the sky is falling, but it is important to arm yourself against those. And it does give you peace of mind. I think to your point, like explaining why it legitimizes your business, it really does. It makes you a legitimate business in the eyes of the IRS or other various governing bodies that would be looking for reasons to reclassify you or come after you. So 2 more questions for you. I am a one-woman show, and I feel I've got a lot of years ahead of me of building and scaling this, but actually bringing in legal counsel full-time is a long way off. But this is really interesting. This shift towards fractional, I've seen it in areas, fractional CEOs, fractional COOs, CTOs. I would love to hear more. What would a fractional general counsel look like? How embedded are they in the type of structure of the company?
Yeah, and I know that you just had Guillermo Fisher on, and I know he provides fractional CTO services. And I think you're right. We are moving toward this, and I think it's because there's a need in the market for expertise, but maybe not full time, right? You need somebody on your side, but you can't afford them full time. And I think there's a lot of people too who don't really want to be full time, right? They want to have their own thing. They want to provide, they want to help small businesses, and they want to help a bunch of them. So the way that looks in the law is, I think it can look a lot of different ways. And again, this all comes back to, as a business owner, you should feel empowered to negotiate the rate and the structure that works best for you in conjunction with your attorney, right? Like that should be an open and honest conversation that you have with your attorney about what can you afford, what are you looking for, what are your needs, right? And that can really help inform what the relationship looks like. But if you're somebody who has hires a lot of independent contractors, and you have maybe an independent contractor agreement per month that you need reviewed, that independent contractor agreement is maybe going to take like an hour to 2 hours to review, and then maybe another half an hour to hour conversation with you. So maybe you can extrapolate from there how many hours about you're going to need per year in fractional GC services. So it really can morph and shape to your need. But I'd say you need a fractional GC if you have regular legal questions that you're doing research on the internet to find the answers to, and you feel about 50-50 on whether you've gotten the answer right, okay? That's when a fractional GC could be really helpful to you. And then this other concept of fractional assistant general counsel, let's say you are a company that has a general counsel, but they don't have any other attorneys. Not all attorneys know how to do all things, right? So like, for example, if you're a company looking to take your company public and you want to do an initial public offering, I am not your guy. Okay. I don't know anything about that. You don't know what you need. And so I'm going to give you to somebody else. Okay. Now you may have a general counsel that's all they've ever done. And the reason you hired that general counsel is because in 5 years you want to go public. So you hired the general counsel that's going to get your books and all of your stuff right to be able to go public in 5 years. But you have 50 employees and they need leave and they need disability accommodations, and they need, all sorts of things and handbooks. And you're like, our GC doesn't actually know how to do that because this GC has never worked in that space before. If you have those types of questions and the GC isn't somebody who like either has the bandwidth or the expertise to handle, but you're having these regular sort of questions come up, that's when you might need a fractional assistant general counsel.
This is really exciting, this idea, again, where the market could be further embracing these prevalent skill sets in the market. There are so many talented people who, to your point, either want to do this because this is where this really feeds their soul and they love the idea of helping a lot of different companies at one point, or it's just the fact that the market actually is truly demanding this and not on a full-time capacity. So I think it's a combination of both. So I think this is an exciting time where there's the right people and the market is starting to embrace it more. A last question, because we are still at the early weeks of 2024. What is top of mind for you this year?
So I think my main goal this year in 2024 is really to build my practice. So I'm within a firm. I work for a firm called Parker Daniels Keyboard, and it's a great bunch of people. We do really good work. Our bread and butter is litigation and trial. We're trial lawyers. All of us here are. And we also do advisory services. But for me, I think I'm at a point in my career where I've kind of done a lot of things. I've been to a lot of places. I've been at a lot of different law firms, and I know who I am in the space. I know what my strengths are in the space. And now I want to make my own mark within the community and start working with clients who want me as their attorney, and like, I'm happy to provide them with the whole panoply of services that Parker Daniels Keyboard can also provide them. I mean, obviously, with the team behind me, I'm able to do so much more for my clients. But I want clients who want me as their attorney and who want to call me when they have something going wrong. So I've been focused a lot on building my brand on LinkedIn, on building my brand through things like this, on networking with not other attorneys necessarily as much as other business owners, just so that if they ever need a legal service, they have someone who they feel like they can talk to and they can turn to and they can trust. So that's what I'm hyper focused on this year. And it's been a lot, as you know, it's been a lot of hard work, like to really commit to building a brand and to building yourself into a commodity, that somebody wants to buy is a lot of work, but it's really fulfilling work. And actually, I had an opportunity to go in-house, which means that I would be a full-time attorney for a company. And part of the reason I turned it down is because I have this like really entrepreneurial mindset. Not only do I like being an entrepreneur, I like building business. I like working with people who are entrepreneurs. I like to help your business while I'm growing my own business, because it's exciting for me when a client comes to me and is like, we've got these new leads and we've got to sue these people because they breached this contract. And if we let them breach the contract, then all these other people are going to breach the contract as well. And like, that's so exciting. Like, let me be a part of the growth of your company, and it feeds my soul to be a part of other people's entrepreneurial journey. So that's where I'm at with my career. And then also, I want to be like a better mom and a better wife and a better friend and a better sister and a better daughter. But, and I also want to deadlift PR. I want to deadlift my body weight. So those are the things I'm focused on in 2024.
Hell yeah. Well, I think those are all phenomenal goals. And I don't know if you agree with this, but you mentioned again, it is a lot of work being out there and marketing yourself. It's insanely gratifying to attract people into your orbit because you're more vulnerable, because you're more out there, you're doing the damn thing, you're doing the hard stuff, and people show up into your life that inspire you. And the more authentic and the more vulnerable you are, people tend to mirror that and the right people show up. So I think keep doing what you're doing. I love your personal brand. Again, we all have one, whether we like it or not. And some of them are great, like yours. Others could use work, but I think you're doing all the right things. And I'm just so grateful to be in your orbit. And I'm so grateful for what you shared today, because whether you're an employee listening, an independent contractor, a new business owner, a well-established business, we all need help. Cody, thank you so much for sharing all those insights. I think you did help dethrone the idea that this is only for the rich, famous, the ultra wealthy, as I talked about at the beginning, that we can all call our attorney. Thank you so much again for joining me today on Cupalo Conversations, and thank you for being in my life.
Thank you for having me, and thank you for being in my life.